Welcome to The Explainer. Today, we're diving straight into a high-stakes and, honestly, pretty stressful part of running a business, workplace disputes in the Gauteng region. Specifically, we're looking at disciplinary hearing chairperson services in Johannesburg, with insights straight from VCA Consulting. Look, if you run a business or manage a team, how you handle internal disputes is literally a make or break situation. It can either shield your company or leave you wide open to massive financial hits. We're going to break down exactly why, and trust me, this stuff is fascinating.
Okay, let's dive into this. 24 months. Just think about that for a second. That is how much a botched internal hearing could cost an employer in terms of a dismissed employee's pay. Why? Well, because if an untrained or biased chairperson ruins an internal hearing, and the CCMA, that's the Commission for Conciliation, Mediation, and Arbitration, finds the dismissal automatically unfair, the employer pays the heavy price. A standard unfair dismissal claim usually starts at around up to 12 months of pay, but it can easily double to 24 under those more severe circumstances. That's a staggering financial blow, right? And it literally all traces back to whoever is sitting at the head of the table on day one of that disciplinary hearing.
This whole situation boils down to Section 188 of the Labor Relations Act. It sets a very strict legal baseline for South African employers, stating that a dismissal must be for a fair reason and follow a fair procedure. South African labor law absolutely does not mess around when it comes to due process. So whoever you appoint to chair that hearing, they have to deliver that required fairness on the day. They're essentially the gatekeepers here. If your process is flawed from the get-go, even if you have a perfectly valid operational reason for letting someone go, you're almost certainly going to lose when it eventually goes to arbitration.
Now, to really grasp the sheer scale of this risk, we have to look at Johannesburg. The concentration of formal employment here is just massive. We're talking about everything from the big financial institutions in Sandton to the logistics operators and huge manufacturing hubs spread all across the wider Gauteng region. And with that high employer density comes a much higher volume of workplace disputes and CCMA referrals compared to businesses in smaller centers. It makes sense, right? More people, more daily interactions, well, more opportunities for conflict. Because the volume is so high, the risk of a mismanaged hearing just slipping through the cracks is also incredibly high.
So, here is where businesses usually set a massive trap for themselves. They appoint an internal line manager to chair the hearing. I mean, think about how awkward this actually is in practice. You are asking someone to formally judge their own colleague. They usually know the employee personally. Heck, they probably share a break room. Because of that shared history, they very often have a prejudged view on what the outcome should be long before the hearing even starts. Plus, it's incredibly tough for them to separate everyday operational frustration from the actual objective evidence presented in front of them. When you make an internal manager play judge, it is way too easy for an employee to claim bias on review. You're basically handing an aggrieved employee an easy win at arbitration.
But here's the thing, that 24 months of pay, that is just one slice of the pie. You also have to factor in the legal fees required to defend a botched process. Then there's the massive drain of lost management time, pulling managers off their actual day jobs to prep for and sit through hearings, and then dealing with the CCMA fallout. It just destroys productivity. And let's not forget the reputational cost of a public finding against your company. When you add all this up, it becomes crystal clear that relying on an untrained internal chairperson ends up costing a business far more than simply bringing in an independent one from the very start.
So what's the alternative? Well, the law points us toward an independent chairperson. Now, it's important to note that South African labor law doesn't actually require an admitted attorney or a lawyer to run a hearing. But what it absolutely demands is a competent, impartial person. They need to have zero prior history with the case or the parties involved. They can't have any personal stake in the outcome whatsoever, and they must be able to weigh the evidence without bias and apply your disciplinary code consistently. It is all about strict impartiality. They run the hearing fairly, rule on any procedural objections that pop up on the day, and ultimately protect the integrity of the process.
Now, what's really interesting about this slide is how stark this contrast is when you put the two options side by side. On the internal manager side, you've got a super high risk of bias claims, a massive disruption to your staff's time, written records that are often informal or just incomplete, and totally variable consistency across different departments. But flip over to the other side. An independent chairperson from VCA Consulting brings zero history with the case. That drastically lowers your CCMA risk because a properly documented process is so much harder to challenge.
Plus, you get zero disruption to your internal staff, a full written finding with actual reasoning, and uniform application across your whole business. Seeing it laid out like this makes the choice to outsource this specific function feel like an absolute no-brainer.
And this perfectly builds into VCA Consulting's seamless three-step solution, because it is not just about having someone show up on the day. Step 1 is impartial chairing, where an external practitioner, who is registered with the South African Board for People Practices, by the way, runs the hearing from that very first notice all the way to the finding. Step 2 is providing written findings. And Step 3, this one is huge, CCMA representation. If the employee does challenge the outcome, the exact same practitioner who chaired the hearing and knows the case inside out will represent the employer through conciliation and arbitration. It is complete end-to-end protection.
I really want to highlight why Step 2 matters so much. A VCA chairperson doesn't just give you a quick verbal verdict and walk away. They provide a reasoned, fully written outcome detailing exactly why they reached their finding and sanction. Why is this absolutely crucial? Well, if that case is referred to the CCMA, this written finding is usually the very first document a commissioner is going to read. Just imagine the impact of handing over a crisp, legally sound, and completely unbiased written record. It instantly establishes your credibility, and it literally becomes your absolute best defense.
Now, you might be wondering exactly who you're handing the reins over to. Rest assured, the VCA Consulting isn't some new experiment. They have been operating as a national HR provider and outsourced consultancy handling exactly these kinds of disputes since 1996. For decades, they've been chairing hearings, managing complex grievances, and representing employers. This is a deeply established service built specifically for businesses across Johannesburg and the wider Gauteng region who know the immense value of relying on tested, proven expertise.
And here is where this all connects to the bigger picture for business owners. Look, disciplinary hearings rarely happen in a vacuum, right? VCA Consulting actually provides really comprehensive HR and industrial relations support. Very often, an employer will bring them in for a hearing, but realize a single retainer can cover a whole array of compliance obligations. We're talking grievance handling, drafting your disciplinary code, employment equity consulting, skills development facilitation, BBBE consulting, and even payroll and health and safety services. They can essentially keep your entire compliance calendar on track while simultaneously shielding you from dispute risks. It's the whole shebang.
Which brings us to the most important question for you to take away today. Who is chairing your next hearing? Is it a frustrated line manager who already kind of knows the outcome they want? Are you risking up to 24 months of a dismissed employee's pay, hefty legal fees, and reputational damage just to keep this awkwardly in-house? Seriously, don't wait for a botched process to hand an employee an easy win at arbitration. Review your internal processes today. Think about the immense value of an independent, impartial expert, and maybe seek out VCA Consulting's expertise before you find yourself in the hot seat. Thank you so much for joining me for this explainer. Stay curious and keep learning.